This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're dealing with a who's on first situation where an insured and an insurer's burden on causation was resolved by the United States Court of Appeal for the Fifth Circuit because proof of accidental direct physical loss on an all-risk policy shifts the burden to the insurer to prove an exclusion applies, and an insured must prove actual loss caused by a named peril on a contents or named peril policy. In Mark Alan Barger Jr. and Margie Barger versus State Farm Fire and Casualty Company, the United States Court of Appeal for the Fifth Circuit on March 7, 2025, dealt with the differences between the burden of proof needed for an all-risk coverage and a named peril coverage. Mr. Barger appealed the district court's grant of summary judgment in favor of their homeowners insurer, State Farm. The Bargers contended that the district court, in evaluating their insurance claim, erroneously assigned them the burden of proving that a specified named peril or covered event caused damage to their roof and necessitated its replacement. In June of 2021, a storm in Greenwood, Mississippi, caused significant rainfall, rainwater leaking through the Bargers' roof and interior ceilings, causing damage to multiple rooms in their home. State Farm refused to cover the cost of replacing the entire roof, concluding that only 9 wind-damaged shingles and a small area of roofing membrane were covered by the policy. The Bargers eventually paid for a new roof in March of 2022 and then sued State Farm for breach of contract. The district court granted summary judgment in favor of State Farm, reasoning that the Bargers failed to prove that a covered event caused the additional damage. Analyzing the issues before it, the Fifth Circuit noted that under Mississippi law, when an insured makes a claim under an all-risk coverage, the insured only needs to prove that an accidental direct physical loss occurred to their dwelling. Once established, the burden shifted to the insurer to prove that a policy exclusion applied, and the Bargers were able to establish that their roof was damaged and it leaked. State Farm maintained that the district court's reference to coverage B rather than coverage A had no impact on the application of the burden of proof and was nothing more than a clerical error that did not affect the outcome of the case and should be disregarded as harmless. However, the language of the Coverage A dwelling section of the Bargers State Farm policy unquestionably provided all-risk coverage, whereas the Coverage B personal property section only covers property loss caused by certain specified perils referred to as, quote, named perils, coverage of Coverage C personal property. The Bargers were required to prove by a preponderance of the evidence that the direct physical loss to the property described in Coverage C was caused by wind. The Fifth Circuit was convinced that the district court improperly allocated the burden of proof regarding causation to the Bargers rather than to State Farm. The Fifth Circuit was not convinced that the error had no impact on the district court's summary judgment decision. Therefore, the Fifth Circuit reversed the district court's summary judgment ruling, vacated the dismissal of the Bargers' breach of contract claim, and remanded the case back to the district court for further proceedings. In my opinion, the State Farm policy contained two different types of coverage: one, an all-risk policy for the structure, and two, a named peril coverage for the contents. The district court erroneously applied the named peril coverage to the entire claim when it should have applied the all-risk requirements to structure and named peril requirements to the contents. The Bargers fulfilled the all-risk requirement and shifted the burden to State Farm, but may not have fulfilled the named peril requirement for loss to their contents, so the court reversed and returned the case to the district court to rule on both aspects of the policy. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also have access to the more than 5,000 blog postings. You can also subscribe to these videos. They're free. And please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publications. Thank you for your attention.